Hello and welcome to the deep dive. Today we're really getting into something quite, well, intricate in international disputes.
Yes, we're looking at situations where an English court might have the power to hear a case, but chooses not to.
Or, even more actively, tries to stop that case from happening somewhere else entirely.
Exactly. And before we dive in, we should mention this deep dive is based on educational materials made available to students by the University of London.
Absolutely. Full credit to them for these resources. They're invaluable. And just to be clear, these discussions are purely for educational purposes.
Definitely. We hope this helps you, especially if you're studying these areas.
That's the plan. Also, this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And for everyone gearing up for exams,
Yes. Very best of luck from both of us.
the very best of luck. These topics, they need careful navigation.
They really do. So we've talked before about when an English court gets jurisdiction, the rules that let a case even get through the door.
Right. But just because the door's open doesn't mean the court will actually hear the case out.
So having jurisdiction isn't the final word.
Not at all. English courts have these significant powers, tools, really, to decline jurisdiction if they think another place is better suited,
Or, as you said, sometimes they step in to stop litigation happening abroad.
which is quite a sensitive thing to do, as you can imagine.
It sounds like it. Like the court saying, okay, you can come in, but maybe you shouldn't stay. Or even, hold on, stop trying to go over there.
That's a pretty good way of putting it. We're focusing on two main tools today. First, there are stays of English proceedings.
Stays, like hitting pause.
Essentially, yes.
Yeah.
Pausing or halting the case here in England. This often forces the claimant, the person suing, to go to a foreign court instead. Or, and this is important, to go to arbitration if they'd agree to that.
Okay, so a stay stops the English case.
That's the effect. And this power, it comes from the court's inherent jurisdiction. It's a fundamental power.
And the second tool.
That's quite different. It's the restraint of foreign proceedings.
Right.
We achieve this using something called an anti-suit injunction.
Anti-suit injunction.
Oh.
Sounds serious.
It is. And the crucial point here, really vital to grasp, is that this injunction isn't an order to the foreign court. English judges don't boss around judges in other countries.
Right, that makes sense.
Instead, the order is aimed squarely at the party involved in the English case. It tells them, the litigant, you are forbidden from starting or continuing that case in, say, France or New York.
Okay. So a stay is the English court controlling its own process, closing its door. An anti-suit injunction is the English court telling someone in front of it to stop bothering another court.
That's a very clear way to distinguish them. And because anti-suit injunctions inevitably impact what happens in another country's legal system, they're used very cautiously.
Because of that idea of respect between courts.
Exactly. The principle of judicial comity. It looms large here. Mutual respect.
Okay. So what's our goal today? Lay out when each of these happens.
Precisely. We want to explain the tests, the circumstances, the rules the courts use to decide. Should we grant a stay? Or should we grant an anti-suit injunction? We'll unpack the differences, especially between anti-suit injunctions and that doctrine called forum nonconvenience, which is actually one of the reasons for a stay.
Right, forum nonconvenience, we'll get to that. So the plan is stays, first forum nonconvenience, agreements about foreign courts, arbitration agreements, then anti-suit injunctions.
That's a solid plan. Let's start with stays.
Okay, Section 1, stays of English proceedings. So when a court grants a stay, what's actually happening to the case?
Well, the case in the English court is effectively put on a hold, suspended, or sometimes stopped altogether in that court. Now, stays can be temporary for lots of reasons, but in this international context we're discussing, it usually means the court is declining to hear the case fully.
I'm pushing it somewhere else.
Yes, requiring the claimant to go to what the court deems a more appropriate place,
Yeah.
maybe a foreign court, maybe arbitration. It's about redirecting the litigation.
And this power comes from where?
From the court's inherent jurisdiction, its fundamental ability to manage its own proceedings, to ensure justice is done properly. And sometimes properly means deciding the case belongs elsewhere.
Got it. So the first big reason for a stay is this doctrine, forum nonconvenience. You said it evolved.
That's right. Forum nonconvenience. It's Latin, means inconvenient forum. It's the core idea that even if an English court technically has jurisdiction, it can still refuse to hear the case if it decides it's just not the right or the most suitable place for the trial.
So it's not just about can we hear it, but should we hear it? Is this the most sensible place?
Exactly. It's about appropriateness, suitability, and the way courts thought about this really changed over time. There was a period, where English courts were quite reluctant to turn cases away.
A bit protective of their own jurisdiction.
You could say that, sometimes described as judicial chauvinism. Lord Denning famously called England a good forum to shop in. The attitude was almost, why wouldn't you want to sue here? But then came a key shift, particularly highlighted in the House of Lords case, the Abbott and Daver, 1984. That case signaled a move away from that thinking towards greater judicial comity.
There's that word again, comedy.
Yes. Lord Diplock, in the Abbott and Daver, explicitly said judicial chauvinism was out, comedy was in. Respecting other courts, other legal systems became much more central.
So thinking more globally, less inwardly.
Precisely. And that shift really set the stage for the modern approach, which was definitively laid down by Lord Gough in a really landmark case, the Spiliata, 1987.
The Spiliata. You said, remember this one.
If you take away one case name today, make it the Spiliata. It established the fundamental two-stage test that English courts still use today to decide whether to grant a stay based on forum nonconvenience.
Okay, the Spiliata, 2 stages. Let's break that down. Stage 1, what happens there?
Okay, stage 1. Here, the spotlight is on the defendant, the person being sued. It's their job, their burden, to convince the court of 2 things.
2 things.
Yes. First, that there is another available forum, another court somewhere else that can hear the case. And second, that this other forum is clearly more appropriate than England for the trial.
So the defendant has to point somewhere specific and say, look, that place is obviously better suited than England. Keywords, defendant, available forum, clearly more appropriate.
Exactly. Those are the pillars of stage 1. Now, let's look at available forum. For a while, it seemed straightforward just meant a place where the defendant could actually be sued.
Seems simple enough.
It did. But then a Court of Appeal case, Mohammed v. Bank of Kuwait in '96, added a wrinkle. They suggested the forum had to be available in practice.
In practice, what did that mean?
Well, in that case, the claimant was Iraqi, the bank was Kuwaiti. Suing in Kuwait was practically impossible for the claimant because of the political situation, legal restrictions. The court felt this practical impossibility meant Kuwait wasn't really available.
But doesn't that sound like an issue of fairness or justice? Something you'd expect later?
It does, and that's exactly the criticism. Later cases, like Askin v. Absa Bank, and crucially the House of Lords in Comley v. RTZ Corp., clarified things. They said, look, issues like whether you can actually fund the case or practical hurdles making a trial impossible or unjust, those belong in stage 2.
Okay, so the modern view puts those practical justice issues in stage 2.
Generally, yes. So for stage 1, available forum usually just means can the defendant be properly sued there. Practical problems about getting justice done come later. Don't get too hung up on where Muhammad put that issue.
Got it. Available usually means jurisdictionally possible. Now, the second part of stage 1, showing the foreign forum, is clearly more appropriate. How does the defendant do that?
This is where the court dives into the connecting factors. It's about looking at all the links the dispute has with different countries.
Connecting factors? Like what?
Things like convenience. Where are the key witnesses? Where are the important documents? Expense. Where will it be cheaper to run the trial? Where do the parties live and work? Critically, what law governs the actual dispute? Is it English law or the law of that other country?
So weighing up all these practical links.
Exactly. The court uses these connecting factors to try and identify the natural forum.
The natural forum.
Yes, the place the dispute seems to naturally belong. The jurisdiction with which the case has the most real and substantial connection.
Okay, like finding the case's home base.
That's a good way to think about it. There's an older case, Rockware Glass, LTD v. McShannon from '78, before Spiliata, but it shows the principle well. 4 Scottish workers injured in accidents in Scotland. They sued the English parent company in England.
But everything happened in Scotland.
Pretty much. The accidents, the workers, the witnesses, the medical evidence, all strongly connected to Scotland. Even though the English court had jurisdiction over the parent company, Scotland was clearly the natural forum, so the English proceedings were stayed.
Makes sense. If all the action and evidence points to one place, that place is probably clearly more appropriate.
That's the idea. Lord Gough and Spiliata summed it up. A stay should only be granted if there's another available forum that is clearly more appropriate, where the case can be tried more suitably for the interests of all the parties and the ends of justice.
What if it's not so clear-cut? Maybe there are a couple of other countries involved, but Neither seems obviously better than England.
Good question. That came up in European Asian Bank, AGV Punjab, and Sind Bank. Remember that name? European Asian Bank.
Mm.
German bank sued an Indian bank in England. The dispute involved things happening in both India and Singapore.
So connections to multiple places.
Right. The defendant wanted to stay, arguing for either India or Singapore. But the court looked at it and said, well, yes, India and Singapore have connections, but neither one is clearly more appropriate than England.
So if the defendant can't point to one single foreign forum that's definitely clearly better.
Then they haven't met their burden in stage one. If no single foreign forum stands out as clearly more appropriate, the English court will usually refuse the stay at this point, and the case stays in England.
Okay, so stage one is quite a high hurdle for the defendant. Identify a specific available forum and prove it's clearly better. If they manage that, then what?
If the defendant successfully jumps that hurdle in stage one, we move to stage two. And here, the game changes. The burden shifts.
Shifts to the claimant, the one who wanted to sue in England in the first place.
Exactly. The burden shifts squarely onto the claimant. Now they have to convince the court of something.
What do they have to show?
They have to show that there are special circumstances, something relating to the requirements of justice, that mean the case should still proceed in England, even though stage one established there's a clearly more appropriate foreign forum.
Requirements of justice. This feels like where fairness really kicks in.
It is. But there's a general rule here, flowing from Spiliata. The claimant usually have to take the clearly more appropriate foreign forum as they find it. Meaning, they generally can't refuse to go just because the foreign system is less advantageous for them. Maybe the procedure is slower, maybe legal aid isn't as good, maybe they can't recover as much in damages. Those kinds of disadvantages are usually not enough on their own to stop a stay.
So just because England offers a better deal for the claimant isn't a good enough reason to ignore the natural forum?
Not usually, no.
Yeah.
The exception, and this is crucial, arises only in exceptional circumstances. Cases where being forced to litigate in that clearly more appropriate foreign forum would actually amount to a denial of substantial justice.
Exceptional circumstances, denial of substantial justice. This sounds like a very high bar, too.
It is. It's for situations where the disadvantage is so severe that the claimant effectively cannot get a fair trial or pursue their case properly in the foreign country at all.
And this is where those cases you mentioned, Connolly and Lube, become so important. They define these exceptional circumstances.
Absolutely critical cases. Let's take Connolly v. RTZ Corp. plc, 1998. Repeat that. Connolly v. RTZ. Mr. Connolly lived in Scotland. He sued RTZ, the big English parent company, and its English subsidiary here in England.
What was the case about?
He claimed he got cancer from working in a uranium mine in Namibia. The mine was run by RTZ's Namibian subsidiary.
Okay, so the harm happened in Namibia, linked to a Namibian company, but the lawsuits in England against the parent, Namibia seems like the obvious natural forum.
It was. And Mr. Connolly actually conceded that Namibia was the place with the closest connection. So, based on stage one, a stay looked pretty likely.
But then came stage two.
Exactly. In stage two, Mr. Connolly argued he couldn't get substantial justice in Namibia. Why? Because he couldn't get the funding, the financial help needed to actually run his case there. It was a very complex claim, needing loads of expensive expert medical evidence to prove the link between the mine and his cancer. That kind of funding help was available in England.
So the lack of money to pursue a complex case in the natural forum was the key argument.
It was the absolute key. The House of Lords agreed with him. They said forcing him to go in Namibia, where he effectively couldn't afford to bring the case properly, especially given its complexity, would be a denial of substantial justice.
Wow. So even though Namibia was the better geographical fit.
The practical impossibility of actually trying the case there without the necessary funding was deemed an exceptional circumstance. So the stay was refused. The case stayed in England. It really underscored that justice isn't just about where the events happened. It's about whether the claimant can realistically access the legal process.
That seems like a huge deal. That practical inability to litigate because of lack of resources abroad can keep a case in England, especially for big global companies.
It is a very significant principle, and it was reinforced and maybe even extended in Lub v. Cape Pila.
Yeah.
Rapid, repeat. This involved nearly 3,000 South African claimants. They were suing Cape Plake, an English parent company, here in England. The claims were for asbestos injuries suffered back in South Africa, allegedly caused by Cape's South African subsidiaries.
Okay, similar setup. Harm in South Africa, suit in England against the parent. South Africa looks like the natural forum again.
It was.
Yeah.
And Cape Lake even agreed to be sued in South Africa, so it was definitely an available forum. Stage 1 was clearly met.
So the burden shifted to those 3,000 claimants. Why should their cases stay in England?
Their argument focused on funding again, but slightly differently. They relied on contingency fee agreements, basically no win, no fee arrangements with their lawyers. These were crucial for funding such a massive group action. They were available in England.
But not allowed in South Africa at the time.
Exactly. The House of Lords, following the logic of Connolly, said yes, this matters. For a huge, complex, mass tort claim like this, the complete absence of contingency fee funding in South Africa was enough. It meant the claimants couldn't realistically bring their cases there at all. So, again, exceptional circumstances, denial of substantial justice, stay refused.
So Lubb confirms that specific funding mechanisms like contingency fees needed for big group cases can also be grounds for refusing a stay in Stage 2.
That's right. Loeb also touched on human rights arguments, the idea that stopping a case due to lack of funding might breach the right to a fair trial under the European Convention. Lord Bingham essentially said the Scagliata Stage 2 test already covers this. If a claimant genuinely can't get the funding and legal help they need for justice abroad, but can get it in England, a stay won't be granted. The courts try to ensure justice is actually possible somewhere.
The implications seem pretty clear. English parent companies operating overseas, especially in places where it might be hard for claimants to fund complex lawsuits, are potentially more likely to face those lawsuits here in England now.
It certainly opened the door wider in those specific circumstances where justice requires it, particularly around funding complex claims. It's this ongoing tension, isn't it, between the principle of the most connected forum and the need for justice to be practically achievable.
Okay, so that's FNC, the Scagliata two-stage test, defendant's burden in Stage 1 on appropriateness, claimant's burden in Stage 2 on justice, with Connolly and Lua being key on exceptional circumstances like funding. What's the next reason for a stay?
The next situation is where the parties have actually agreed beforehand, where they'll resolve disputes. They've put a foreign jurisdiction clause in their contract.
Ah, so they've picked their court already. How does the court handle that? Does it differ from FNC?
It does differ. When there's a foreign jurisdiction clause, the starting point is different. There's a prima facie rule.
Prima facie, meaning at first sight.
Exactly. At first sight, the rule is that if someone brings a case in England in breach of an agreement to sue somewhere else, say they agreed to sue only in Germany, the English action will be stayed. The court starts by assuming the contract should be upheld.
So the default is stop the English case, follow the contract.
That's the general starting point, yes, respecting the parties' agreement. But, and this is crucial, it's still discretionary. It's not automatic. The court can allow the English case to go ahead if the claimant shows strong cause, why it should, if justice requires it.
Okay, strong cause. So unlike FNC Stage 1, where the defendant had to show the other place was better, here the claimant, who's trying to sue in England despite the agreement, has to show a really compelling reason not to enforce the agreement.
Precisely. The burden flips completely compared to FNC Stage 1. The claimant has the tough job of proving strong cause against granting the stay. The guiding principles for this discretion were set out clearly in the Eleftheria, 1970. Repeat that name. The Eleftheria.
The Eleftheria. What did it say about this strong cause discretion?
It laid down some key points. First, the court has discretion. Second, that discretion should normally be exercised in favor of granting the stay, upholding the contract, unless the claimant shows strong cause not to. Third, the burden is on the claimant. Fourth, the court looks at all the circumstances of the case.
Okay, claimant's burden, strong cause, look at everything. What kind of circumstances count towards showing strong cause?
Well, the factors often look similar to the FNC connecting factors, but the perspective is different. The court considers things like, where's the evidence? Is it convenient and cheap to get it here or there? Does foreign law apply? Where are the parties connected? Is the defendant just trying to get a procedural advantage by insisting on the foreign court? And critically, would the claimant be prejudiced if forced to sue abroad?
Prejudice again. Like in FNC Stage 2.
Similar concept, yes, but focus on the consequences of enforcing the clause. Would the claimant be unfairly disadvantaged? For instance, would they lose security for their claim? Would they be unable to enforce a judgment they might get abroad? Has the time limit expired in the foreign court but not here? Or, crucially, is there a serious risk they wouldn't get a fair trial abroad, maybe due to political reasons, racial bias, or something similar? That overlaps with the denial of justice idea from FNC.
So the court respects the contract, but not blindly. If enforcing it means real injustice or effectively prevents the claimant getting a fair shot, the court might override it with strong cause.
That's the balance they strike. And again, echoing a point from another case, the Ella Maria, judges usually try to avoid just comparing the quality of justice systems in general. It's not about saying English justice is better. It's about whether substantial justice can be done for this claimant, in this case, in the chosen foreign forum.
Okay. How might a claimant try to argue strong cause or get out of the clause? Can they just, say, frame their claim differently?
Trying to be clever with the claim form generally doesn't work. You can't usually avoid a jurisdiction clause that covers contractual disputes just by calling your claim a tort claim, for example. That was shot down in a case called the Sind. Repeat, the Sind. The court looks at the real substance of the dispute.
Can't plead your way around the agreement. Makes sense.
Exactly. A more direct route is to argue the jurisdiction clause itself is invalid or unenforceable. Maybe the whole contract is void, although sometimes the jurisdiction clause can actually survive even if the main contract fails. That happened in Trentex Trading Corp v. Credit Suisse.
So the agreement on where to sue can stand alone sometimes.
It can. But a more common way a clause gets knocked out is because of a specific law, a statute. The key case here is the Hollandia, 1983, repeat, the Hollandia.
The Hollandia, what happened there?
It involved a shipping contract, a bill of lading, which said all disputes had to go to court in the Netherlands, an exclusive Dutch jurisdiction clause. However, the contract was also subject to an English law, the Carriage of Goods by Sea Act 1971, which incorporates international rules called the Hague-Visby Rules.
Okay.
And one of those rules, Article 3, Rule 8, says any clause in a shipping contract that lessens the ship owner's liability below a certain standard is automatically null and void. The court found that forcing the cargo owner to sue in the Netherlands under Dutch law would lessen the carrier's liability compared to what it would be under the Hague-Visby rules applied in England.
Ah, so the jurisdiction clause itself had the effect of reducing the carrier's responsibility, which the statute forbids.
Precisely. Therefore, the House of Lords held the Dutch jurisdiction clause was null and void by force of statute. The English court wasn't bound by it.
That's a really important point. Legislation, especially implementing international standards, can override private agreements on where to sue.
It absolutely can, particularly in areas like shipping, where there are strong protective conventions.
Yeah.
So, for foreign jurisdiction clauses, remember, the ELA theory, claim its high burden, strong cause, and that clauses can be invalid, especially if they clash with the statute, like in the Hollandia.
Right. So we've had stays for inconvenience, FNC, and stays for agreeing to a foreign court. What's the third main situation? Agreements to go to arbitration.
Yes, arbitration agreements. And this is treated quite differently again because there's specific legislation, the Arbitration Act 1996. The consequence is very different.
Different how?
The key difference is that if certain conditions in the Act are met, the English court is generally required to grant a stay of the court proceedings. It's not usually discretionary.
Required. Mandatory.
Pretty much, yes. Section 9 of the Arbitration Act 1996 says that if there's a valid arbitration agreement covering the dispute and a party starts court proceedings in breach of it, the other party is entitled to a stay as long as they ask for it properly and haven't already accepted the court's jurisdiction, like by filing a defense. Repeat, entitled to a stay.
Entitled. That sounds much stronger than the other situations. What are those conditions in Section 9?
The main ones are, 1, you need an arbitration agreement in writing, which Section 5 defines quite broadly. 2, the court case must be about a matter that the agreement says should be arbitrated. The court dispute has to fall within the scope of the arbitration clause. 3, the arbitration agreement itself must not be null and void, inoperative, or incapable of being performed. 4, the party asking for the stay, usually the defendant, must not have taken steps in the court case that amount to submitting to the court's jurisdiction. They need to ask for the stay promptly. 5, and the dispute itself must be something that can legally be settled by arbitration under English law.
So if you have a valid written deal to arbitrate something that's arbitrable and someone ignores it and goes to court, the other side can basically demand a stay and the court has to grant it.
That's generally the strong effect of Section 9. It reflects a very clear policy from Parliament favoring the enforcement of arbitration agreements. The court's job is mainly just to check if those statutory conditions are met. There isn't the wide discretion you see with FNC or foreign jurisdiction clauses.
Okay, that's a very clear distinction. So the three main stay scenarios, FNC, Cibiliata, discretionary balancing act, foreign jurisdiction clauses, eleftheria, discretionary but prima facie stay, claimant needs strong cause, and arbitration agreements. Arbitration act, generally mandatory stay if conditions met, defendant entitled.
Excellent summary. Getting those differences in the tests and the burden of proof straight is really key for understanding this area.
Great. Okay, let's shift gears now. Section 2. Restraint of foreign proceedings. Moving from stopping English cases to stopping cases elsewhere, using anti-suit injunctions. This feels like a bigger step, doesn't it? More intrusive.
It absolutely is, and that's why the courts approach it with significantly more caution. As we said earlier, English courts cannot order foreign courts around. They can't tell a judge in Berlin or Tokyo to stop hearing a case.
Right.
So the anti-suit injunction is directed personally at a party who is subject to the English court's jurisdiction. It's an order telling that specific litigant not to start or not to continue a case in a particular foreign court. Repeat, directed at the party, not the foreign court.
So the court tells the company or person, you stop suing over there.
Exactly. But even though it's a personal order, everyone knows the practical effect is to interfere with litigation in another country. And that potential clash with the sovereignty and processes of another state means comity, that principle of mutual respect, is a huge factor.
Okay, so given the sensitivity, what are the actual grounds? When will an English court issue such a powerful order?
The source material groups the grounds into roughly three main categories. One, where the conduct of the party suing abroad is considered unconscionable. This is often described using terms like vexatious or oppressive. Two, where the foreign lawsuit interferes with or threatens some legal or equitable right that the party asking for the injunction has under English law. Three, where starting the foreign case is itself a breach of an agreement between the parties, typically an arbitration agreement or an exclusive English jurisdiction clause.
Okay, let's take the first one. Unconscionable, vexatious, or oppressive conduct. That sounds like pretty bad behavior. How is it defined?
It's notoriously difficult to define precisely, as the Privy Council noted in Société Nationale Industrielle Aérospatiale Villiquijac. We'll call it Aérospatiale.
Right.
Repeat. Aérospatiale. It's about finding the line between legitimately using a foreign court, maybe because it offers some advantage, and using it in a way that's fundamentally unfair to the other side, causing them serious injustice or amounting to an abuse.
So it's not just choosing a court that helps you, it's choosing one in a way that really screws over the other party unfairly.
That's the essence of it. The aerospatial case itself is a good illustration. Remember the helicopter crash in Brunei? Claimants sued in Texas? The Privy Council eventually granted an anti-suit injunction to stop the Texas case.
Why?
Brunei was found to be the natural forum. The Texas proceedings were deemed vexatious and oppressive, primarily because the defendants, the helicopter company, could not bring a claim for contribution or indemnity against a third party they blamed for the crash in Texas. That third party could be sued in Brunei, but not Texas.
So being sued in Texas fragmented the case. They couldn't get everyone involved in one place, which they could in Brunei.
Exactly. That inability to join the third party in Texas, meaning the defendants couldn't pursue their full defense and potential recovery there, was held to cause them serious injustice. This made the Texas proceedings oppressive in the circumstances justifying the injunction.
So serious injustice to the defendant in the foreign court is a key indicator of vexatious or oppressive conduct needed for an anti-suit injunction.
It often is, yes.
Right.
Another example is Midland Bank PLC v. Laker Airways Ltd. 1986. Repeat, Midland Bank v. Laker Airways. Laker Airways sued Midland Bank, both English, in the U.S., using U.S. antitrust laws. But the dispute was about banking activities done in England governed by English law.
No real U.S. connection.
Very little relevant connection. The English court granted an anti-suit injunction. Pursuing the claim under U.S. law in the U.S., when the whole thing was basically English, was seen as unconscionable conduct.
So choosing a forum with little connection just to access different, perhaps more favorable laws can also be seen as oppressive.
It certainly can be, especially if the link to the chosen forum is tenuous and the natural forum has strong connections. And this brings us right back to comedy. Repeat.
Comedy.
Respecting other legal systems. Yes. Anti-suit injunctions are powerful medicine. Their use has to be balanced against not trampling on the processes of other countries. Lord Gough again, this time in Airbus Industry GIE v. Patel, 1999, stressed this caution. He suggested an injunction might be appropriate if the foreign proceedings themselves somehow lack legitimacy or if there's a very strong reason rooted in English justice.
What about the English court's own connection? Does England need to be involved somehow?
That's a crucial point, highlighted precisely by Airbus Industry v. Patel. Repeat, Airbus Industry v. Patel. Remember the plane crash in India? English claimants sued the manufacturers, French, German, etc., in Texas. The manufacturers then asked the English court for an anti-suit injunction to stop the Texas case.
So, India crash, English claimants, European manufacturers, Texas lawsuit, English injunction sought. Where's the English link to the actual dispute?
Exactly the question the House of Lords asked. And they found there wasn't one, really. The crash was in India. The key parties and evidence were elsewhere. Just because the claimants happened to be English wasn't enough to give the English court a legitimate interest in interfering with the Texas proceedings. Comedy dictated restraint. England needed a more substantial connection to the dispute itself to justify issuing an injunction with cross-border effects.
That's really important. An anti-suit injunction isn't just about whether the foreign case is inconvenient or unfair. The English court needs its own stake in the matter, some connection, to justify intervening.
Precisely. England doesn't act as the world's litigation traffic cop just because an English party is involved, if the dispute itself is fundamentally foreign.
Okay. What about the other grounds? Breach of legal rights or breach of agreement?
These often overlap. A party might argue the foreign case breaches some right they have under English law, but more commonly, it's about breach of contract specifically, starting foreign proceedings when you'd agreed not to.
Like agreeing to arbitrate or agreeing to use only English courts?
Exactly those situations. If there's a valid arbitration clause, or particularly an exclusive jurisdiction clause choosing England, and a party ignores it and sues abroad, that's generally seen as a strong reason to grant an anti-suit injunction. It's about protecting the contractual bargain.
So if you promise to sue only in England, the court will usually stop you suing elsewhere.
That's the general rule, yes. As stated by Lord Justice Steen in Continental Bank NAV Ecos Campania Nevira SA, an injunction should normally be granted in such cases, unless there are special countervailing factors. Repeat, special countervailing factors.
Special countervailing factors sounds like the strong cause for jurisdiction clauses or exceptional circumstances for FNC, reasons to deviate.
Similar idea, yes. Factors that might persuade the court not to enforce the agreement via an injunction, even though it's being breached. Donahue v. Armco Inc., 2002, is the key example here. Repeat, Donahue v. Armco Inc.
What happened in Donahue?
There was a clear exclusive English jurisdiction clause, but the court refused to grant an anti-suit injunction to stop related proceedings happening overseas.
Why? Why not enforce the clause?
Because the court found a powerful special countervailing factor. The overall situation was incredibly complex, a multi-party dispute with lots of different claims against various defendants. The foreign court, despite the English clause, was the only place where the entire sprawling dispute involving all the parties could realistically be heard together in a single tribunal.
So stopping the foreign case would have meant splitting everything up across different courts.
Exactly. Forcing the claimant to sue only in England would have fragmented the litigation massively. The court decided that the practical need for efficient case management, getting the whole complex mess sorted in one go, outweighed the contractual promise to sue only in England in this specific, complex, multi-party context.
So even a clear contractual right to an English court isn't absolute if sticking to it creates huge practical problems for resolving the overall dispute efficiently.
Precisely. It shows the power remains discretionary, balancing the contract against the wider interests of justice and efficient litigation, especially in complex international cases.
Okay, let's try and sum up anti-suit injunctions. Target the party, not the foreign court. Use with caution due to comedy. Grounds include vexatious suppressive conduct causing serious injustice abroad, aerospatiale Midland Bank, or breach of agreement, especially exclusive English jurisdiction arbitration clauses. But injunctions might be refused if England lacks connection, Airbus industry, or if there are special countervailing factors like needing a single tribunal, Donahue v. Armco.
That's a very good summary. And the key, again, is seeing these grounds are different from FNC. It's not just about inconvenience. It's about unconscionable behavior or breaches of specific rights or agreements, all viewed through that lens of comedy.
Fantastic. Right, we've covered stays, FNC, foreign clauses, arbitration, and anti-suit injunctions. Let's pull it all together now in Section 3, especially thinking about what listeners need for exams.
Good idea. Section 3. Connecting the dots and key takeaways for the exam. So, the big picture. English courts have these tools to manage where international cases are heard, even if they could technically hear them. Stays stop the English case, redirecting it based on Spiliata FNC, Eleftheria foreign clauses, or Mandatory Arbitration Act rules. Anti-suit injunctions stop a party suing abroad based on aerospatiale unconscionable conduct or breach of agreement limited by Airbus industry comedy.
And the burden of proof, that's crucial to nail down, isn't it?
Absolutely critical. Remember, FNC, Stage 1, defendant shows clearly more appropriate forum. Stage 2, claimant shows exceptional circumstance denial of justice. Foreign jurisdiction clause, prima facie stay. Burden on claimant to show strong cause against the stay, eleutheria. Arbitration agreement, generally mandatory stay if conditions met. Defendant is entitled, burden on claimant to show why agreement doesn't apply or is invalid.
And for anti-suit injunctions, comity is the ever-present check.
Always. Respect for other systems. England needs a good reason, a connection, to interfere even indirectly.
Okay, lightning round recap of the key cases. I name it, you give the headline principle. Ready?
Go for it.
The Spiliata,
Forum nonconvenience, the two-stage test.
the Aberdeen-Dover,
Shift towards judicial comedy, FNC thinking.
Connolly and Lube,
Exceptional circumstances in FNC Stage 2, denial of substantial justice, especially funding access.
Rockware Glass,
Identifying the natural forum using connecting factors. FNC Stage 1.
the Eleutheria,
Foreign jurisdiction clauses prima facie stay. Claimant shows strong cause against it.
the Hollandia,
Foreign jurisdiction clause voided by statute. Hague-Visby rules.
the Sind,
Can't avoid jurisdiction clause just by pleading tort instead of contract.
Midland Bank v. Laker Airways,
Unconscionable conduct, suing abroad with little connection, justifying anti-suit injunction.
Aerospatiale,
Vexatious oppressive conduct, serious injustice to defendant abroad justifies anti-suit injunction.
Airbus Industry v. Patel,
Comedy limits, anti-suit injunctions need English connection interest.
and Donahue v. Armco.
Special countervailing factors. Example, need for single tribunal can defeat anti-suit injunction despite exclusive English clause. Perfect. Nailing those cases and their core messages is vital.
Okay, let's tackle some common exam-style thoughts. First, just reiterate. FNC, the two stages. Why the burden shifts.
Right. FNC equals inconvenient forum stay. Stage 1. Defendant proves another available forum is clearly more appropriate, natural forum. Stage 2. If Stage 1 met, burden shifts to claimant to prove exceptional circumstances mean justice requires staying in England, denial of substantial justice abroad. Why shift? Because once Stage 1 shows the other place is prima facie better, the claimant needs a compelling justice-based reason to override that finding.
Does FNC end up encouraging forum shopping? People picking England not because it's the natural forum, but for other advantages?
It's a perennial debate. The aim is the natural forum. But Stage 2, especially Connolly and Lube focusing on funding and access to justice, can result in cases being heard in England that might not proceed elsewhere. Critics might call this forum shopping for resources or favorable procedures. Supporters say it's ensuring access to justice isn't denied purely by lack of funds abroad. It's a balancing act.
And when can courts look at fairness abroad? You said they avoid comparing systems generally.
They avoid general comparisons, yes. Ilemria. The focus isn't, is England's system better? It's, can this claimant get substantial justice in that foreign forum for this specific case? Only in exceptional situations where they effectively cannot, maybe total lack of funding for a complex case, clear political bias, etc., will the court intervene based on problems abroad. It's about practical impossibility of justice, not abstract system comparison.
Core difference again. Foreign jurisdiction clause versus arbitration agreement, if you want to stop an English case.
Foreign jurisdiction clause gives a strong argument for his stay, eleutheria. But it's discretionary. Claimant can argue strong cause. Arbitration agreement, if valid under the Act, gives the defendant an entitlement to a mandatory stay. Much more certain outcome for the defendant wanting to stop the court case.
Lastly, Connolly and Lube. Have they made it too easy to sue big English parent companies here for things subsidiaries did overseas?
That's the heart of the debate those cases raise. They undeniably created a clearer path for such lawsuits if justice requires it, particularly regarding funding for complex claims that couldn't proceed in the foreign natural forum. This promotes accountability and access to justice for claimants, potentially from less resourced legal systems. But it also means English HQs face litigation here for overseas events, increasing their exposure and potentially burdening English courts. It's a major consequence of balancing global corporate structures with the need for effective remedies.
Understanding those tensions and policy implications seems just as important as knowing the rules.
Absolutely. Knowing the tests, the cases, and the underlying rationale and consequences, that's what makes for a strong understanding for exams and beyond.
This has been incredibly helpful, really breaking down these complex powers English courts have to manage where international disputes get resolved.
We've navigated stays, FNC, foreign jurisdiction clauses, arbitration agreements, and the more sensitive anti-suit injunctions, looking at the tests, the burdens, and the key cases for each.
It's clear it's not just about whether a court can hear a case, but a whole second layer of deciding if it should or if it needs to step in regarding litigation elsewhere, balancing convenience, contract, justice, and that crucial idea of comedy.
It really is a complex balancing act. And maybe a final thought for you to consider. As business and potential harm become increasingly global, how do these doctrines, developed largely in the 20th century, continue to adapt? How do courts ensure that justice remains accessible and effective across borders in the 21st century?
That's a great question to leave us with. Thank you so much for guiding us through all of that today.
It's been a pleasure. And genuinely, to everyone listening and preparing for exams, the very best of luck.
Yes, the best of luck from us. Thanks for joining the deep dive. Until next time.